Aquino, Representative Ilago, and Representative Ko. We shall begin with the De Jesus complaint, and at this juncture, we recognize the Honorable Nisay to manifest his position with respect to the sufficiency of substance of the De Jesus complaint.
Good morning, Madam Chair, colleagues, and all esteemed guests. The De Jesus impeachment complaint being sufficient in form, it may now be examined for its substantive sufficiency bago ito magpatuloy sa mga susunod pang stage ng impeachment proceedings. Kung susuriin, ang impeachment complaint ay nakabase sa tatlong ultimate grounds of impeachment. 1. Graft and corruption. 2. Culpable violation of the Constitution. And 3. Betrayal of public trust. Dinipay na ng ating Korte Suprema sa kasong People versus Palasige, citing Martel versus People, ang mga salitang graft at corruption. Base dito, graft is the fraudulent obtaining of public money unlawfully by the corruption of public officers. It also refers to advantage or personal gain received because of the peculiar position of superior influence of one holding a position of trust and confidence without rendering compensatory services or dishonesty transaction in relation to public or tax. Sa kabilang banda naman, dinipay nito ang corruption in its fundamental sense as the act of an official fiduciary person who unlawfully and wrongfully uses his station or charter to procure some benefit for himself or for another person. Contrary to duty of the rights of others, it pertains to an act done with an intent to give some advantage inconsistent with official duty and the rights of others. Kasama sa De Jesus complaint ang aligasyon na ang totoong layunin ng pagbuo ng ICI ay para protektahan ang mga taong punot dulo ng korupsyon sa bansa. Kapansin-pansin nga naman na walang nangyaring pag-imbestiga ang ICI sa mga pangalang ikinanta ng taong kanilang tinutugis ngayon at napabalitang nasa Portugal at Sweden. Dagdag pa, bigla na lamang natapos umano ang layunin ng ICI pagkatapos lumutang ang pangalan ng Pangulo na siya umano ang may utos ng lahat. Partikular na ang pag-deliver sa kanya ng mga quote-unquote basura. Hindi biro ang mga bilyones na laman ng mga maleta na kung tawagin nila ay basura. Ang mga basurang ito ay dugot pawis ng mga mamayang Pilipino na tapat na nagbabayad ng buwis ng buong tiwalang ang perang ito ay gagamitin para sa ikauunlad ng lahat. Ang basura pong ito ay kayang-kayang magpagaan at magsalba ng buhay ng mga Pilipino. Ang mga basura pong ito ay kayang makapagpakain, makapagpaaral at makapagpa-ospital at makapagbigay ng maayos na tirahan sa bawat pamilyang mas nangangailangan. Ngunit ang basurang ito sa kasamaang palad ay di umano ginamit para sa pangsariling interes ng iilang tao lamang at kasama na diyan di umano ang ating Pangulo. Pangalawa, culpable violation of the Constitution. Binanggit na ito ni kagalang-galang na si Father Bernas sa kanyang komentary na The 1987 Constitution of the Republic of the Philippines. A komentary na the culpable violation of the Constitution must be understood to mean willful and intentional violation of the Constitution and not violations committed unintentionally or involuntarily, or in good faith or through an honest mistake of judgment. Kasama sa complaint ang aligasyon na nagkaroon ng Pangulo ng pag-bypass sa ating justice system, ng kanyang hinayaang maipadala ang dating Pangulong Presidente sa ibang jurisdiksyon, partikular na sa International Criminal Court, para doon litisin. Nangyari ito sa pamamagitan ng pagkilos ng PNP na alam nating lahat ay sumusunod at nasa ilalim ng direktiba ng ating Pangulo. Pangatlo, betrayal of public trust. Sa kasong Emilio Gonzales versus Office of the President acting through the represented by Executive Secretary Paquito N. Ochoa Jr. et al., sinabi ng ating Korte Suprema na the Constitutional Commission eventually found it reasonably acceptable for the phrase betrayal of public trust to refer to acts which are just short of being criminal but constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary powers. In other words, acts that should constitute betrayal of public trust as to warrant removal from office may be less than criminal but must be attended by bad faith and of such gravity, seriousness as the other ground for impeachment. Malinaw na papasok dito ang aligasyon ukol sa failure ng Pangulo na ibito ang unprogrammed appropriations at ilang special provisions nito sa ating mga national budgets. Naiintindihan din natin na walang legal duty ang Pangulo na magbito ng items dahil discretionary ito sa ating saligang batas. Ngunit naniniwala tayo na dapat kalaki pa rin ang moral aspect sa issue na ito. Hindi ba naging prioridad at magiging prioridad ng Pangulo ang usapin sa kalusugan at kakulangan dito? Hanggang kailan magiging one hospital away from poverty ang mga Pilipino? Tama naman na ito ay short of being criminal, but such failure to act already constitutes a gross faithlessness against trust, a gross exercise of discretionary powers. Kahit Korte Suprema rin ay dineklara ng unconstitutional ang pag-transfer ng pondo mula sa PhilHealth na nilipat sa National Treasury. At bilang isang health advocate, nabahala tayo sa naging issue na ito, particular sa 60 billion pesos mula sa 2024 PhilHealth Reserve Fund. Ang pondong ito ay nararapat lamang sa pagpapalakas ng ating universal healthcare system at magamit ito ng mga Pilipinong higit na nangangailangan. Ang pondong ito ay nararapat lamang na matulungan ang mga pasyenteng hirap sa bayarin, maisaayos ang mga hospital at health units na nakakulang sa kagamitan at pasilidad, at mapataas ang benepisyo ng ating mga healthcare workers. Naniniwala tayo na kung hindi na mauulit ang katulad na problema, siguradong panalo at makikinabang at mamamayang Pilipino. Madam Chair, nahiyag din sa complaint ang revelasyon ni Senator Amy Marcos tungkol sa paggamit ng ipinagbabawal na droga ng Pangulo. At ang katotohanan na walang naging malinaw at direktang naging sagot dito ang Pangulo. Batid kong umaasa ang sambayan ng Pilipino na ang namumuno sa kanila ay isang taong intelektual at hindi impluensyado ng droga o anumang harmful at illegal substance. Again, inaction of the President with regard to these allegations may be considered as gross faithlessness against public trust. Tandaan natin, walang gagawa ng mali ang ipapakita o sasabihin sa lahat na siya ay gumagawa ng mali. Masigit lalo na walang taong nasa mataas na posisyon ang personal na gagawa mismo ng mali. Kaya rin sa ating justice system, particular sa Revised Penal Code of the Philippines, may tinatawag na principle by direct inducement. Kung susuriing mabuti, ang mga aligasyon na ito ay tumutumbok sa isang conclusion, that the President most likely is not anymore fit to govern. Malayo pa ang proseso, pero malayo na ang narating ng hangarin na magkaroon ng mas maayos na pundasyon ng ating pamahalaan. Madam Chair, in view of the foregoing, I respectfully submit that the impeachment complaint be deemed sufficient in substance and that it accordingly be allowed to proceed to the next stage of the proceedings. Magandang araw po muli sa ating lahat.
Thank you, Honorable Nisay. That completes and concludes his manifestation of position in as far as sufficiency in substance of the Jesus complaint is concerned. We understand that at the end of our deliberation on the sufficiency on substance with respect to this impeachment complaint of Attorney De Jesus, we will be voting on the entirety of the impeachment complaint. Nonetheless, for purposes of clarity of our proceeding, considering that there are 5 offenses alleged, anchored on 3 grounds, we will be eliciting the comments, opinions, and questions from the members of the committee in accordance to the grounds alleged in the impeachment complaint. Let the chair reiterate that while we discuss it on the basis of grounds at the end of our deliberation, we will be voting on the sufficiency in substance on the entirety of the impeachment complaint. At this point, we will be eliciting the comments, positions, or even questions of the members of the Justice Committee with respect to the sufficiency in substance of the Jesus complaint, which position was manifested already by our endorser, the Honorable Nisay. We will begin with the first offense. Let me read. Respondent ordered and enabled the kidnapping and surrender of former President Rodrigo Roa Duterte to the ICC. This is the offense charge, and the same is anchored either any or all of the following grounds: culpable violation of the Constitution or betrayal of public trust. Members who wish to manifest.
Madam Chair,
The Honorable Ridon is recognized.
I think prior to even talking about anything else, I think we need to state for the record that what is important in the submissions would be two things, no? Personal knowledge or authentic records that had been submitted as part of the impeachment complaint. For the first impeachment complaint, may we know from the Secretariat on what the annexes, on which annexes had been submitted as authentic records, Madam Chair?
May we ask the endorser if he is willing to answer the question instead of the Secretariat answering the question? The Honorable Ridon is asking on the annexes attached to the complaint in support of the offense of kidnapping and surrender of the former president to the ICC.
To be clear, Madam Chair, this is not just a question on the specific ground, but as a general question on all of the submissions, because you have annexes here, but we would want to know whether what had been submitted are authentic records, particularly whether the submissions are certified through copies of particular official documents. Madam Chair.
The chair stands corrected. The question pertains to the entirety of the impeachment complaint.
And to explain why we are asking this, in previous impeachment complaints, the complaints had been rejected by the House Committee on the basis of that these impeachment complaints had not been submitted because on the basis of personal knowledge or because of submission of authentic records. So I think the same standard
Point of order,
should apply
Madam Chair.
to.
Point of order.
The Honorable Ilaga is recognized with the indulgence of the Honorable Ridon.
Representative Ko.
Honorable Ko.
Okay. Thank you, Madam Chair. Madam Chair, to my understanding, for now, we are in the stage of assessing the sufficiency of substance of the impeachment complaints. We are observing Rule 3, Section 5 of the 20th Congress Rules of Procedure in Impeachment Proceedings, which provide the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. So for the purposes of this exercise, Madam Chair, what we need to do is to determine whether in the complaint there is a recital of facts which, one, provides the jurisdiction of this committee, and number two, whether it constitutes the offense charged. So we do not yet need to enter into a discussion whether the recital of facts actually is based on personal knowledge or based on authentic records. That can come later, Madam Chair, in the hearing proper, when the committee has already determined whether there is sufficiency in substance, whether the facts alleged in the complaint constitute the offenses that are being charged, which in the case of Honorable Nisa, would be corruption, betrayal of public trust, etc.
Any member who wishes to
Madam Chair.
respond? The Honorable Tino is recognized.
Thank you, Madam Chair. In addition to the point made by Representative Ko, I would like to point out that the matters raised by the Honorable Ridon have already been settled in yesterday's proceedings, namely the determination of sufficiency in form, where precisely the committee found that it was indeed sufficient in form, meaning that the complaints, both complaints were verified complaints based on personal knowledge and/or authentic records. So that point has already been settled as far as the rules provide. No? And any further discussion on those is out of order at this stage.
The Honorable Chua is raising his hand.
Madam Chair, hindi po ako I will not dispute kung ano man po yung kanilang sinasabi. Kasi kanina po binabasa ko lamang po itong mga... Dito pa lang po tayo sa una, tama po ba? Dito po sa kidnapping, tama po ba?
With due respect, the Honorable Chua, there is a pending query on the validity of the question of the Honorable Ridon with respect to the attachments to the impeachment complaint of De Jesus. This is being disputed by the Honorable Ko and the Honorable Tino, as they are claiming that this should be asked after the determination of sufficiency in substance, if I stated it correctly. So let us dispose first this matter before we proceed to other issue. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. As already been pointed out repeatedly, narration of facts, which means that it excludes bare allegations. This is an impeachment complaint, and we are at the stage of determining sufficiency in substance, which should contain narration of facts. The definition of facts, it must be distinguished from bare allegations, because bare allegations are not evidence. We should concentrate on whether or not, yes, we have to deal on the four corners of the complaint, but we should see if there are narration of facts which are not bare allegations which can possibly lead to a proof that there is constitutional violation, which is an impeachable offense. Madam Chair, Your Honor. So I do not agree that just allegations will be considered to determine sufficiency in substance. I
Madam
respectfully submit.
Madam Chair.
The Honorable SDML is raising his hand. SDML Lawrence Defensor is recognized.
Thank you, Madam Chair. If we look at the heading of Section 5 of our Rules of Impeachment, it says, determination of sufficiency of substance. It's not acceptance of a recital. The word determination, it bears emphasizing that it is upon the responsibility of this committee not simply to accept a recital in an impeachment complaint. We have the duty to determine it with diligence. And it is not acceptance merely of allegations. It is determination of facts, which should at this stage be at least supported to determine whether there is sufficient or probable cause. That will be further heard in the proper hearing by this committee. So it is only proper that the recital of facts should at this stage be at least supported by evidence for us to declare that the complaint is sufficient, not only in form, but also in substance. Thank you, Madam Chairman.
Thank you.
Madam Chair.
The Honorable De Lima, and then Honorable Co, and then Honorable Tino, and then Honorable Garbin. Okay, one after the other. And then Honorable Rodriguez. The Honorable De Lima is recognized.
Thank you, Madam Chair. Good morning, everyone. Technically and strictly, and if we go by the standard set the House rules itself, the rules of procedure in impeachment proceedings, it's supposed to be just, we just have to look at whether the complaint has a recital of facts constituting the impeachable offense charged and determinative of the jurisdiction of this committee. I don't think there's any issue on the jurisdiction. This committee has jurisdiction. Now, the recital of facts constitutive of impeachable offense charge, in addition to what has been articulated earlier by the Honorable Chairperson about, it must not be based on conclusions. I would wish to further elaborate on exactly what sufficiency in substance mean. When we talk about substance, it refers to whether the complaint alleges ultimate facts that, if hypothetically admitted, would constitute an impeachable offense. So hypothetical admission lang. Hindi pa natin titingnan kung totoo o hindi, o may supporting evidence ang isang allegation of fact. And as I said, in addition to the standards set in our own rules of impeachment, rules in impeachment proceedings, a complaint is sufficient in substance when it, number one, narrates specific acts or omissions, not mere conclusions. Number two, it shows a nexus, a connection between the acts complained of and an impeachable ground. Kailangan konektado yung mga allegations of facts doon sa constitutional ground. Number three, should be intelligible and coherent, allowing the respondent to meaningfully answer. Number four, it's not purely speculative or opinion-based. And then, pwede rin, in terms of just checking the sufficiency of the entire complaint, whether we can also look into whether it's supported by annexes or references, although proof need not yet be conclusive. Dahil nga po, evidence is not weighed at this stage. The test is allegational sufficiency, not credibility or truth. Yun po ang aking position. Thank you very much.
Thank you, Honorable De Lima. Now we recognize the Honorable Co.
Thank you, Madam Chair. Good morning to the committee. Once again, I also submit and I agree with the manifestation made by Representative De Lima. And I would just like to add further in regard to the discussion on ultimate facts. Given that actually the rules of court superiorly applies to the rules on impeachment under Section 19, I'd like to read Rule 8 of the Rules of Court of the Philippines, wherein it says that pleadings are required to set forth ultimate facts on which the party relies for a claim or defense. And as stated earlier, the ultimate facts are generally what is the allegation of the offense, the acts or omissions, and how it relates to the offense charge. That's different from evidentiary facts, which is not required to be included in a pleading yet, and that can come later on when we enter the hearing proper. And it's different also from conclusions of law. So right now, what is on the floor is the determination whether the ultimate facts are alleged in the pleading. And so given that we're at this stage right now, we will determine whether the complaints are sufficient in substance as to whether ultimate facts alleging the offense charged is sufficient for this body. That's all. Thank you.
For the guidance of all the members, our parliamentary status, we are determining whether or not the question of personal knowledge and authentic records, specifically with respect to the attachments, should be considered in the determination of sufficiency in substance. Moving forward, we now recognize the Honorable Tino.
Thank you, Madam Chair. The Honorable De Lima and Co, they have eloquently made the point that at this stage, this committee is not supposed to determine facts. This is not the proper stage for that. That will involve the hearing proper. No? So at this point, the complaints may be determined as sufficient in substance if they are found to allege facts that constitute a ground for impeachment. Hanggang dun lang po. Hindi pa po natin papasukin kung totoo ba talaga o hindi yung mga allegations sa complaint. Yun lang po, Madam Chair. And as to the question of authentic records and so on, my position there is that dapat tinanong yun kahapon. Dahil yun yung precisely, yun yung inaalam, no? Whether or not the verification requirement was satisfied. At ang sinasabi dun sa verification that the complaint is based on personal knowledge and or authentic records. And that has already been settled by the committee. Thank you, Madam Chair.
Thank you, Honorable Tino. Now we recognize the Honorable Garbin.
Thank you, Madam Chair. We are all guided here by the rules of impeachment of this House, and the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. The complaint before us, filed against the President, alleging impeachable offenses, namely culpable violation of the Constitution. Major allegations by category is the surrender of former President Rodrigo Roa Duterte to the ICC. It is noteworthy to mention, Madam Chair, and to this honorable committee, that the case before the Supreme Court questioning the constitutionality of the said alleged surrender and kidnapping, case of GR number 278762 in the matter of the petition for the writ of habeas corpus of Rodrigo Roa Duterte is still pending. In fact, the status of the case right now is that parties were required to file position papers. And so, therefore, Madam Chair, to my mind, these are mere conclusions, not established facts, Madam Chair. And later, I will manifest my findings on the major allegations such as the culpable violation of the Constitution, and will declare my vote and explanation to my vote, Madam Chair. Thank you.
While the opinion of the Honorable Garbin on the first offense is significant, we will be holding our discussion on the first offense until we thresh out the question on whether or not we will consider the attachment if they are authentic record for the purpose of determining sufficiency in substance. That is our parliamentary state right now. The Honorable Rodriguez.
Madam Chair, after hearing the discussions, I am fully satisfied.
So before we proceed to our discussion on the offense, that is kidnapping, we wish to thank the significant views and opinions as to the question of whether or not the attachments should be considered for the purpose of determining sufficiency in substance, no? And I understand that there are varying opinions. Some members would say or said that they should not be considered and we should stick on what are stated in the impeachment complaints, while some would say that they are necessary for the purpose of determining the substance or the sufficiency in substance. The chair wishes to elicit a motion as to whether or not we will include the attachment if they are authentic records for the purpose of determining sufficiency in substance as a preliminary matter.
Madam Chair.
The Honorable Ko.
Okay. Madam Chair, I move that for this portion of the discussion, the body contemplates whether the facts alleged in the complaints constitute the offense charged. And at this stage, we do not need yet to cross-check or check it whether it is supported by the evidence, be it based on personal knowledge or authentic records. I so move, Madam Chair.
Madam Chair,
The Honorable Rodriguez.
point of order.
The Honorable Rodriguez is
The
recognized.
Honorable Ko is a party of the case as the endorser also in these particular proceedings. And so therefore, we will request all the endorsers that in the deliberation of the committee, they cannot participate. This is a proceeding akin to a preliminary investigation. And so the complainant and their lawyers could not be the one moving to the prosecution to proceed with the case. And so therefore, with due respect, let us allow our members, and of course, we will appreciate you at the proper time in the discussions to elaborate further the complaints. But as already parties, the party is the De Jesus complaint, Attorney De Jesus, and Jet Nisay, the endorser. Masa, the three respected gentlemen and lady. And so, the other party is the President Ferdinand Bongbong Marcos. And we are the committee investigating. So therefore, let us wait for another member to move whatever is the motion about. So I would like to seek the ruling of the chair.
Would you like to comment to that, Honorable Ko, before we rule?
Okay. Thank you, Madam Chair, Honorable Rodriguez. While I understand the logic of the manifestation, we'd just like to manifest that the three complainants of the second impeachment complaint are members of the Committee on Justice. So again, we also respectfully seek the ruling of the chair in regards to this matter, whether or not we can participate in the deliberations of the discussion on the first impeachment complaint, because as at least provided by the rules, it is a right that is provided upon the members of the Committee on Justice. Thank you, Madam Chair.
The chair recognizes the right of each member of this committee, notwithstanding his dual capacity of being an endorser as well. So, in resolution of the question as to the capacity of the Honorable Court to raise a motion, the chair rules in favor of the authority and right of the member, notwithstanding the fact that she is an endorser as well, to raise the necessary motion.
But Madam Chair,
Before that, Madam Chair, we respect that ruling. Would therefore, in the voting of these two complaints, will Representative Ko be voting?
to the honorable members of this committee, we are exercising a very important process, and it is not the intention of this committee to impair whatever right and authority each of the member has in this committee. So if we are upholding the right of a member who is at the same time an endorser to raise a motion, we are likewise upholding her right to vote on the motion. Honorable Ko?
Madam Chair, before I answer, perhaps in the order also of the matters, given that we'd like to thank the Madam Chair on the ruling, but in deference on the discussions, I'd like to retract my motion and would allow the body to make that motion, given that there's this question. But nonetheless, we, as a member and in deference to the ruling of the chair, we will continue to participate in the discussions.
The chair has ruled already.
Okay.
The motion by the Honorable Ko is
Sustained.
upheld by the chair.
Okay.
So I will just be requesting for the rephrasing of the motion because it should not entail the evidence aspect of the attachment. The question only is whether or not the attachments as authentic records should be considered for the purpose of determination of sufficiency in substance. We are not yet on evidence. The Honorable De Lima is recognized.
Given the withdrawal by the Honorable Rene Ko of her earlier motion, may I therefore make this motion? I move to exclude in the consideration of sufficiency in substance the determination